In our last lecture, we discussed the two primary means for assigning citizenship at birth, the jus soli and the jus sanguinis. The United States, of course, is a jus soli nation, meaning that anyone born within one of the 50 states is automatically a United States citizen, regardless of the citizenship of his or her parents. In this lecture, we take a closer look at the history of birthright citizenship in the United States, and we will conclude the lecture with a look at current proposals to change it. In terms of the history of birthright citizenship, it's surprising to learn that there is no constitutional provision, there's no federal statute establishing citizenship at birth in the United States prior to 1868, the post-Civil War period. Nonetheless, it is clear that the states and federal government considered at least white persons who were born in the United States to be citizens automatically. The early colonies and subsequent states followed the English common law rule of territorial birthright citizenship. This is something we inherited from the English common law. As I mentioned, it is not in the Constitution or a statute, but was a practice of the common law that was assumed rather than dictated. Early law treatises, court cases, and other writings reflect this assumption. At least again, for white persons, states seem to have excluded persons of African descent as well as Native Americans. So how do we explain the fact that birthright citizenship in the United States was not formally dictated or formally established until 1868? Part of that story involves the Dred Scott case, which you may be familiar with. This is a United States Supreme Court decision in the year 1857 in which the United States Supreme Court held that all persons of African ancestry, even if free, were not citizens of the United States. This case was one of the precursors to the American Civil War. So after the Civil War and emancipation of several million former slaves, the question is, what is their citizenship? How do you best secure their rights as free persons? One part of that was to establish that they were, in fact, citizens of the states in which they resided, and also that they were citizens of the United States. In terms of accomplishing this, the U.S. Congress first attempted to do so by statute, passing an act that stated all persons born in the United States were U.S. citizens and citizens of the state in which they resided. President Andrew Johnson vetoed that act, and it's important for us to understand why he did so. Here's the veto message, and bear with me as I read it to you. By the first section of the bill, all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are declared to be citizens of the United States. This provision comprehends the Chinese of the Pacific states, Indians subject to taxation, the people called gypsies, as well as the entire race designated as blacks, persons of color, Negroes, mulattoes, and persons of African blood. Every individual of those races born in the United States is, by the bill, made a citizen of the United States. This was one ground for Andrew Johnson's veto of the 1866 Civil Rights Act that contained this provision. We're interested in this veto message because he exhibits two reasons for the veto. The first reason is that President Johnson believed that only the former slaves should be awarded citizenship at birth and not those persons of other races. So he objected to the use of all persons born in the United States. His second ground had to do with federal citizenship and state citizenship. President Johnson was a strong believer in federalism in terms of states' rights, and he thought that states ought to be able to decide who would be citizens. Two other things to note here. When we look at the language of the 14th Amendment, we'll see that the language is slightly different from the 1866 Civil Rights Act. First, look at the language in the second line, not subject to any foreign power. We're going to compare that to the language of the 14th Amendment because it's not exactly the same. Indians not taxed indicated persons who did not live on the tribal reservation and therefore were taxed just like any other person in a state or a community. So excluding those two categories, not subject to any foreign power and Indians not taxed, they would be declared citizens of the United States immediately at birth. Let's now compare that to citizenship in the United States Constitution. The 14th Amendment, Section 1, Sentence 1, reads as follows: all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Section 1 is also important because it contains our Due Process Clause and our Equal Protection Clause. And these are two very, very important constitutional rights for persons in the United States. And let's look at that language. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law. That's the Due Process Clause that I mentioned. And then the last sentence, the last lines here, nor deny to any person within its jurisdiction the equal protection of the laws. So two of our most cherished and important constitutional rights, due process and equal protection, are also included in Section 1 of the 14th Amendment. The 14th Amendment, ratified in 1868, is one of three post-Civil War amendments that are generally designed to guarantee rights of the former slaves, but have since been expanded to cover all persons. Another interesting point to note, look at the Due Process Clause as well as the Equal Protection Clause. Nor shall any state deprive any person. Notice that does not say any citizen. The Due Process Clause is similar to the Equal Protection Clause, nor deny to any person. What this means is that due process and equal protection are equally applicable to non-citizens currently in the United States. So that's Section 1 of the 14th Amendment, embodying some very, very important rights and, of course, the constitutional right of birthright citizenship. Let's look at that language by itself. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I've provided italics for the language that we should explore. Subject to the jurisdiction thereof. What does it mean? What did it mean to the framers? The modern view and modern understanding is that the framers believed they were excluding the children of diplomats and Native Americans living on their tribal reservation. This latter point was established in a United States Supreme Court case known as Elk versus Wilkins, decided in 1884. And I have a quotation here from that case that helps explain subject to the jurisdiction thereof. So I would like to read that to you briefly because of its importance in our understanding that phrase. Members of and owing immediate allegiance to one of the Indian tribes, although in a geographical sense born in the United States, are no more born in the United States and subject to the jurisdiction thereof, within the meaning of the first section of the 14th Amendment, than the children of subjects of any foreign government born within the domain of that government, or the children born within the United States of ambassadors or other public ministers of foreign nations. Native Americans have long been considered to have a form of self-governance known as a dependent sovereignty. It's this concept that the Supreme Court is invoking in Elk versus Wilkins to say that they are not subject to the jurisdiction thereof. Modern law awards citizenship at birth to all Native Americans by statute, so that even though the 14th Amendment has been read by the Supreme Court not to cover Native Americans, they are U.S. citizens, and it is by act of Congress. Also, toward the close of the 19th century, there remained uncertainty as to the applicability of the 14th Amendment to persons of other ethnicities. The most important decision, which today is cited and relied upon by many to establish that birth within the United States alone will make one a U.S. citizen, regardless of the nationality of your parents, is a Supreme Court decision that we'll talk about in just a few minutes. We need some historical background for that decision. Late in the 19th century, Congress enacted what has become known, what were known at the time as the Chinese Exclusion Acts. And as the name suggests, they were meant to exclude Chinese from immigrating into the United States and to exclude them from becoming citizens. Here's an image from that period, and it illustrates the United States position here. So you see that the Temple of Liberty, that's the entrance, the port of entry into the United States. You have a petitioner, a Chinese person who is seeking entry into the United States, and you see the line at the bottom of the image, e pluribus unum, out of many one, except the Chinese. Here's another image, also relating to the Chinese Exclusion Act. Here it's referred to as Scott's Exclusion Act, and it's titled The Chinese Question Again. One illustration here is to note that Uncle Sam is unable to keep the door closed. And you see that, at least from the perspective of this editorial cartoon, such exclusions would be futile. It was against this background that the Supreme Court at the end of the 19th century decided a case entitled United States versus Wong Kim Ark. Wong Kim Ark was born in the United States, in San Francisco, to parents who were nationals of China. Wong Kim returned to China for a brief visit. When he sought to re-enter the United States to rejoin his parents and other family members, he was denied entry. While he was away, U.S. law changed to deny entry to persons of Chinese descent, and he was able to obtain help of a lawyer to take his case all the way to the United States Supreme Court. The U.S. government took the position that Wong Kim was not a citizen of the United States because the 14th Amendment did not apply to persons of Chinese descent. Despite the fact that the 14th Amendment said all persons born in the United States, the United States government took the position at the Supreme Court, arguing that this language referred only to former slaves, that it was the intent of Congress and the intent of the states that had ratified this amendment that it refer to only the slaves rather than all persons. The Supreme Court had very little problem dismissing that argument, and here are the most important aspects of its holding. The 14th Amendment is not limited to persons of African descent. All persons means all persons. And then the tricky language, subject to the jurisdiction, excludes children of foreign diplomats, American Indians, and children of occupying forces. All others are U.S. citizens at birth. Now let's talk about the modern controversy over birthright citizenship in the United States. Notwithstanding the fact that for over 200 years we have considered persons born in the United States to be citizens, there are several proposals out there to change that rule. The proposal would change the United States from a jus soli nation, as we talked about that term in the last lecture, to a jus sanguinis nation. One such proposal is the Birthright Citizenship Act of 2013. This is an act that has been introduced for the past 8 years. It, in my opinion, has very little chance of success in the houses of Congress for reasons that I'll talk about later. But let's look at its provisions. What does it do? The Birthright Citizenship Act of 2013 amends the Immigration and Nationality Act to consider a person born in the United States, quote, subject to the jurisdiction of the United States for citizenship at birth, if the person is born in the United States to parents, one of whom is Number 1, a U.S. citizen or national. Number 2, a lawful permanent resident alien whose residence is in the United States. Or 3, an alien performing active service in the U.S. Armed Forces. So who does this not include? First of all, it does not include persons here on temporary visas, such as student visas, tourist visas, and some forms of business visas, because you must be a lawful permanent resident alien. Who else does it exclude? Well, quite obviously, the children of undocumented aliens, and it is this group to which the statute is directed. Persons who object to awarding citizenship to the children of undocumented aliens sometimes base their arguments on the ground of the so-called anchor baby myth. The term anchor baby usually is referring to persons who come to the United States solely for the purpose of having a child here who becomes a citizen, who could then in turn anchor the parent to the United States. The anchor baby phenomenon is largely a myth. First of all, most children who are born to undocumented aliens are born to persons who have lived in the United States for a relatively long period of time. So, in other words, these persons are not clandestinely entering the country simply in order to have children. Second of all, it is not true that having a U.S. citizen child will prevent the parent from being deported. In fact, quite the opposite is true. The United States has deported annually thousands of parents of U.S. citizen children. Usually the children go with them if they are young. The children have a right to return at any point, but they have no right to have their parent return with them. The U.S. citizen child, once he or she reaches the age of 21, may file a petition with the United States Attorney General requesting that the parent be allowed to join the child in the United States. The child must first reach the age of 21 if the parent has been deported, if the parent has violated immigration laws. That petition is very likely to be denied. So for these reasons, the so-called pejorative anchor baby is largely a myth. But back to the Birthright Citizenship Act of 2013. Again, it's been introduced every year for 8 years. It is, in my view, very unlikely to ever be passed, and even if it were to be, it is unconstitutional. You cannot, by statute, by act of Congress, amend the United States Constitution. That's a different process. There are also out there some proposals to amend the United States Constitution, and they mirror this provision here. They would limit citizenship to the children of U.S. citizens and certain others. Changing the rule of birthright citizenship by constitutional amendment would be permitted. The 14th Amendment, after all, was an amendment to the Constitution. But amending the Constitution is a very difficult process. It takes 2/3 approval of both houses of Congress, as well as ratification by 3/4 of the states. In the last 220 years, we have only ratified 17 amendments. The first 10 were ratified in 1791, and those 10 are known as our Bill of Rights. So it's a very difficult process. There does not seem to be sufficient political support for changing the Constitution on the ground of birthright citizenship. Instead, immigration reform seems to focus equally, if not more, on border security. Returning once again to the statute attempts to get around the problem of its constitutionality by defining the word subject to the jurisdiction in the 14th Amendment. So this is how it works. The 14th Amendment provides citizenship to all persons born here, unless they are not subject to the jurisdiction of the United States. So the attempt here is to define that term by statute. I give the Birthright Citizenship Act a 0 chance in Congress as a piece of legislation, but so long as there is even one sponsor, it could be pending for many years to come. I have provided a link in the optional materials to an article that I have written examining the Birthright Citizenship Act of 2013, as well as constitutional proposals. In our next lecture, we will look at citizenship in United States territories and possessions. These areas are not covered by the 14th Amendment, and we will explore the reasons for that.
The preceding program is copyrighted by Emory University.